let's unpack this. I want you to imagine, just for a moment, the absolute nightmare scenario.
A terminally ill patient kept alive only by machines.
Exactly. And years ago, they made a living will, an advance directive, saying very clearly, this is not what I want.
But for 5 years, that document was essentially worthless. The family would try to honor that wish, and they just hit a brick wall of bureaucracy.
And that's the core of it. The 2018 Supreme Court judgment gave the right to die with dignity, but the rules it created were, well, they were almost impossible to follow.
Right. We have sources like the Indian Society of Critical Care Medicine who basically said the guidelines were useless in hospitals.
So today, our mission is to deep dive into the 2023 order that finally performed, the necessary legal surgery to fix this.
And what's so fascinating is the central conflict the court faced. It was this tension between practicality for the patient and safety from potential abuse.
How do you protect people without making the law itself the source of suffering?
Precisely. And the court had this incredible realization that the heavy-handed judicial oversight, the magistrates, the district collectors, it wasn't protecting dignity, it was actively blocking it.
So they shifted the trust.
A fundamental shift. Away from the state bureaucracy and towards the citizen and their doctor. It was a vote of confidence in medical expertise over judicial process in this very specific context.
Which brings us to the biggest game changer. Executing the living will itself.
Okay, so under the old 2018 rules, you needed 2 witnesses, fine, but then you needed a countersignature from a Judicial Magistrate First Class, the JMFC.
And that was the bottleneck that killed the whole thing.
It was. It made it inaccessible.
And that JMFC requirement is now gone. It's out.
Which is massive.
It's huge for accessibility. Now you just need 2 witnesses and an attestation from a notary or a gazetted officer.
I mean, think about that. Making a directive about your end-of-life care is now as procedurally simple as getting an affidavit for a rent agreement.
That comparison just says everything about the shift in trust, doesn't it?
Yeah. It does, and that simplification extends right into the critical care unit, the district collector's role. Gone entirely.
So what replaces it? You still need checks and balances.
I do. The process still involves 2 medical boards, a primary and a secondary. But the key difference is the hospital has to form them immediately. It respects the urgency.
And the timeline.
This is critical. Each board, the primary with the treating physician and the secondary with a nominee from the chief medical officer, they have to make a decision, preferably within 48 hours.
48 hours each.
Yes. And they're even encouraged to use virtual consultations to hit that deadline.
Wait, hold on. I have to ask. Removing the judge, putting a 48-hour clock on it, doesn't that open the door to, family pressure or even malpractice in a high-stress ICU environment?
That's the crucial question, and the court did address it. The safeguard is the multi-level medical check.
Yeah.
You still have multiple doctors signing off, but the real backstop is technology. The magistrate is now only informed after the decision is made, purely for the record. And storage has moved from dusty court files to the National Health Digital Record, the NHDR.
Ah, so it's secure, transparent, and instantly accessible to any doctor anywhere.
Exactly. It adds a layer of transparency that physical paper never could.
So wrapping this up, what does this actually mean for you, the listener?
Well, these new guidelines are now the law of the land until Parliament decides to enact a specific bill. It means doctors can act on a patient's wishes without that constant fear of prosecution hanging over them.
And for an individual.
You can act on this today. You can execute your own advance medical directive without a lawyer. All you need are 2 witnesses and a notary. That's it.
Just make sure you give a copy to your family and, this is critical, your family doctor.
Yes, communication is everything. It makes the whole process work.
And what if the hospital boards say no?
The process isn't dead. You or your family can go straight to the High Court, which is now mandated to hear the case expeditiously. Your voice, through your living will, is still the central authority.
So the law now clearly trusts medical judgment more than judicial checks. Which leaves us with a final thought. Is removing the magistrate a complete victory for dignity, or did we lose a necessary safeguard against potential abuse? That's something to consider as these rules finally give real teeth to the right to die with dignity.